Hello everyone and welcome to today's Mondat webinar in association with O'Sullivan Estate Lawyers, who will be discussing and identifying the key issues regarding estate planning and administration for the modern family. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Margaret O'Sullivan is recognised across Canada and internationally for her trust and estate planning expertise, including complex multi-jurisdictional and cross-border succession matters, a frequent speaker and writer on trust and estate topics. Margaret's practice involves all aspects of trust and estate work for domestic and international private clients, including estate planning, will and trust planning, incapacity planning, estate litigation, advising executors, trustees and beneficiaries, and administration of estates and trusts, with a focus on high net worth, domestic, cross-border and multi-jurisdictional succession issues. Blair Botsford focuses on all aspects of trust and estate law for domestic and multi-jurisdictional private clients, including estate and succession planning, will and trust planning, incapacity and disability planning, probate and guardianship applications, charitable gift planning and private foundations, estate, trust and guardianship administration. In addition, Blair regularly advises financial institutions, charities and other lawyers with respect to trust, estate and related matters. Michael von Keats focuses on estate planning, estate administration and matters directly related to these areas of the law. His experience includes the resolution of complex issues in estate administration with cross-border, multi-jurisdictional and litigious aspects. Michael regularly advises executors, trustees, attorneys and guardians on their duties and obligations. He has also worked with a variety of entrepreneur and family office clients to develop tailored estate plans to clients' unique family succession needs. And completing today's panel is Nicholas Andre. Nicholas focuses on estate planning, estate administration and related areas, including dispute resolution and court work. He frequently advises on testamentary trust, multiple wills, incapacity planning, and complex wealth distributions to achieve creative and sound solutions in succession plans. Nicholas is often retained by executors and other fiduciaries to provide guidance on administering an estate or managing the affairs of an incapable person, and by beneficiaries on their rights, as well as on understanding the intricacies of the estate administration process. Now, before I hand over to the panel to begin today's webinar, a quick housekeeping item. You can submit questions to today's panel by typing them into the questions pane of the toolbar on the right-hand side of your page. The panel will endeavour to answer as many questions as possible during our Q&A session. It's now my pleasure to hand you over to our panel to begin. Thank you.
Well, thank you, Dan, for your kind words and introductions to us, and welcome everyone from many different parts of the world. And I'm delighted to say that we have just under 600 people signed up for the webinar today. And we're delighted that you're going to be here to talk about this very important topic of the modern family. First of all, I'd like to go through the agenda, what we'll be talking about during our presentation today. And the first topic will be globalization of families and the need for cultural intelligence and multi-jurisdictional expertise, followed by blended family challenges, and then next, the modern family and evolving definitions, followed by modern family multi-jurisdictional issues, when wills and trusts cross borders, how to navigate them, and our final topic, gender identity and fluidity and its impact on estate planning. Well, moving to our first topic, we're going to talk about globalization of families. Well, modern families are very different from the families of the past. And in fact, from the time that I've started practice a few decades ago, because they and their assets are just that much more global than before. Really, the purely domestic family is a thing of the past. How many families do you think will have all of their children, all of their grandchildren, all of their assets, all of their family members, their citizenship, their residence, their domicile, only in one jurisdiction? Well, I think going forward, increasingly few. And no doubt, I think the trend is towards more complexity as families and their assets become more globalized. So really, the modern family is the global family for many people, and that's our modern reality. Our culture, and I think increasingly as a result of the pandemic, is just really more nomadic. People increasingly live in several different jurisdictions, sometimes for only part of the year, and they have multiple ties, whether they're retired and active, but working remotely, and with real estate and financial and other assets spread out in several jurisdictions. So that makes estate planning and administration even more challenging today. There's also more immigration, with family members moving to different jurisdictions and more mobility of labor and of capital. In Canada, we've traditionally had an open door policy, which encourages immigration, and we have many new immigrants coming every year with a diversity of cultures, values, attitudes, and traditions. So the typical client of a few decades ago is very different from those of today, and I think will be increasingly so for the clients of tomorrow. As professional advisors, I think the onus on us is not only to have capable technical expertise, but more than ever to have capable emotional intelligence in dealing with our clients, but as well capable cultural intelligence to be successful in dealing with families from different cultural backgrounds. So a one-size-fits-all approach, a top-down approach, is really not a successful strategy. There's a rich diversity which makes successfully carrying out each client's individual objectives and goals more challenging, but really I think a lot more interesting and satisfying than ever before. So in my view, estate planning and administration is not what some think a state and dry area, but instead I think in the context, particularly of the modern family, it's even more vibrant, it's more vital, and it's more relevant than it ever has been before. So how do we become culturally intelligent? Well, I think we need to have an open door, an open mind. We need to be interested in learning about different cultures, different values, traditions, thought processes, approaches, so we can have the necessary understanding to provide guidance in making good choices for each person's unique situation. And if we adopt the premise that each client is unique, well, I think that leads to the imperative of really trying to get into their head so we can successfully carry out their objectives. So we need to understand family structure and hierarchy and the rules and attitudes each culture has, and in particular with regard to inheritance and succession of property, we need to be very culturally intelligent, respectful, and knowledgeable. So in advising families with global connections, along with cultural intelligence, we need also to have capable technical skills to advise on the legal and tax issues which impact them. Now, the body of law, known as the conflict of laws, sets out rules for determining which law will govern a particular succession matter or trust matter. For example, the validity of a will or a trust, whether it's formal validity, such as whether it was signed correctly, or what we call essential validity, such as whether the person who made the will or established the trust had the mental capacity to do so. So for advisors dealing with clients who have multi-jurisdictional connections, it's important that they have a really good, solid understanding of the conflict of laws. As well, the integration of legal and tax planning rules and resulting strategies and opportunities that may be available, but as well the minefields to be avoided, I think is a growing separate area of expertise unto itself. Practitioners really can't operate in silos in their separate jurisdictions, but they must be able to, so to speak, connect the dots when a client has cross-border and multi-jurisdictional issues. So that's it for my overview of the modern family, often now being a global family, and the challenges it poses to advisors and to the families themselves. So now it's time for our first poll question. At this point, you get to be a little more active. If you are an advisor, do you think that advisors in general are culturally intelligent? And if you are a client, do you think that your advisors are in general culturally intelligent? And what percentage are culturally intelligent? I'm going to give you a few moments to provide your answer, and we're going to be very interested to find out what everybody's views are on this topic. Oh, okay. I think we've got our results up for everyone. Very interesting. Only 6% feel that their advisors have cultural intelligence more than 75%. 25% of the attendees think about 50% to 75% do. 49% think about 25 to 50% do, so less than half, and 21% of you think less than 25% do. So I think we think there's a bit of a deficit when it comes to cultural intelligence, if we can make that conclusion. Good, now we're going to move on to our next topic, which is blended family challenges, and I'd like to introduce you to my colleague, Michael von Keitz, who will be addressing that. Michael.
Thank you, Margaret, and thank you to each of you joining us today. As you mentioned, our second topic is blended family challenges. As a starting point, I would suggest that we should consider the definition of a blended family. So when we say blended family, we mean a family formed by two individuals who bring a child or children from previous relationships to constitute a new, cohesive, and integrated family unit. So when we speak of non-blended families, then, we of course mean traditional models, including the nuclear family, but also incohesive and unintegrated family units, including those featuring independent adult children and those where minor children within a family are strictly treated as the children of their biological parent. It's important to determine the type of family you're working with, as the interests of the various parties, the dynamics between them, and the personalities involved can each inform the appropriateness of a particular estate plan. Indeed, as the slide suggests, one size does not fit all. As set out in the rules of professional conduct, a conflict of interest exists where a lawyer's duty of loyalty to his or her client is at substantial risk of being materially and adversely affected by the interests of others. In the context of a blended family, where the interests of the two spouses may not align, caution should be taken to mitigate against such risk. It is best to ascertain the nature of any potential conflicts prior to the commencement of a retainer by asking appropriate probing questions. Oftentimes, one spouse reaches out to the lawyer to initiate the estate planning conversation. This is a prime opportunity, especially if it becomes clear a blended family is implicated, to ask whether the spouse feels a joint retainer may be appropriate in the circumstances. Ultimately, good communication is key, and if a joint retainer is deemed to be the best choice, and if it's to succeed, the parties need to be brought to common ground. To determine whether a joint retainer is appropriate, the lawyer should probe the interest dynamics and personalities involved, as I mentioned previously. For example, does one spouse seem to be influenced by the other? Is there a power imbalance as between the two spouses? Do the children of each spouse get along? Is there a significant difference in net worth or age between the spouses? And do the spouses' intentions align? In planning the distribution of an estate, a number of strategies are open to the will maker, both inter vivos, i.e. during the will maker's lifetime, and on a testamentary basis, i.e. through the will on death, including but not limited to outright distributions to beneficiaries, trusts, including spousal trusts, family trusts, child trusts, etc., joint ownership of assets, being cautious that these are particularly subject to limitations, including the concept of resulting trust, as well as potential unintended tax consequences. There's also the option of bringing debts as between the will maker and his or her children into hodgepodge. There's the designation of registered assets, and there's also the option of cash legacies. These strategies do not need to be implemented independent of one another and can be used in combination. On to the next slide. In conducting a quantitative analysis of the distribution of an estate, the will maker should consider the nature and extent of his or her assets and liabilities, any ongoing support being provided to children, grandchildren, or others, and the property rights held by his or her spouse. What financial resources does each spouse enjoy, and how do they desire for those resources to be directed? Fundamentally, will the proposed distribution best satisfy the obligations of the will maker by ensuring those with a financial interest in the estate are treated fairly? This may be informed by questions as to what standard of living the will maker's dependents have grown accustomed, what role the financial contributions of the will maker, himself or herself, played in allowing that standard of living to be attained, and what ability the will maker has to preserve that standard of living after death. In other words, what are the ongoing and reasonably foreseeable future needs of those with a financial interest in the estate, and to what extent can the will maker meet those needs through his or her estate? It's worth noting that on an intestacy under the Succession Law Reform Act, a surviving spouse is entitled to the first $350,000 in value of the estate, i.e. the preferential share. This value provides a sense of the legislature's view as to a minimal spousal entitlement. In many cases, there are also tax advantages to be enjoyed under the Income Tax Act when transferring assets to a surviving spouse on the basis of a spousal rollover. And can we go back a couple of slides, actually? And one more. When considering a surviving spouse in particular, rolling assets over to a spousal trust is a common strategy. The strategy allows for the protection and preservation of capital while also preserving the wishes of the deceased will maker. Problems can arise, however, insofar as the surviving spouse has no enforceable interest in the capital of the trust, only the income. Only the surviving spouse has any interest in the capital or income of the trust during his or her lifetime, not the children, the grandchildren, etc. And there's a risk of the surviving spouse attempting to collapse the trust by electing an equalization under the Family Law Act. In general terms, the Family Law Act affords the surviving spouse the opportunity to elect between equalization of net family property, much like on a divorce. Death, after all, merely represents another way to end a marriage, and taking what is left to them under the terms of the deceased spouse's will. The election must be made within 6 months of the death of the deceased spouse. Where in effect nothing has been left to the surviving spouse outright, and instead the assets have been transferred to a trust, the surviving spouse may be motivated to equalize. And next slide. If in certain circumstances a tailored estate plan can be vulnerable to upset by a surviving spouse who changes their will, perhaps disinheriting the children of their deceased spouse, what can be done to protect the plan? Mutual will agreements are a tool sometimes used to ensure estate plans are locked in, so to speak, by both spouses. They do not provide the certainty of a spousal trust, but there's growing case law that supports them. These agreements introduce contractual terms concerning the provisions of the spouse's respective wills and become irrevocable upon the death of the first spouse, such that an agreed plan of distribution as between the two spouses becomes binding. Certain issues need to be considered in drafting these agreements, however, allowing appropriate flexibility in addressing concerns related to, for example, remarriage of a surviving spouse. As concerns this particular concern, a portion of the estate could be left with no restrictions so that future changes can be addressed. Note also, as you'll see in the image here, mutual will agreements are often confused with mirror wills. However, these concepts are distinct. Mirror wills are spousal wills, so to speak, whose plans of appointment and distribution mirror one another, which is independent of the question of whether a contract is also in place. Next slide. The choice of appropriate fiduciaries, including executors, trustees, and attorneys, is exceedingly important, especially in the context of a blended family. The interest dynamics and personalities arising on one spouse's side of the family may clash with those of the other spouses. As a result, mutual choices as to appointments may prove inadvisable. Where deemed appropriate, neutral third parties may be good choices to serve in such fiduciary roles. These include trust companies, professionals, and in some cases, friends or other individuals. In particular, although I would not generally recommend appointment of a neighbor or friend in a potentially contentious estate of administration, I have seen such appointments prove successful in the past. In my experience, such individuals should have a degree of sophistication and a strong moral compass. Tread with caution. And at the end of the day, the objective is to avoid an estate plan which is implemented without challenge. The avoidance of litigation is the preferred outcome. To ensure this is the likely outcome, certainty is important. If you mean to exclude your spouse's children and grandchildren from the distribution of your estate, for example, ensure you explicitly exclude them from the definition of my children, my grandchildren, my issue, etc. And that segues nicely with the next topic. My colleague Nicholas Andre will now discuss the concept of defined terms and the need for caution in this area.
Thanks, Michael. So as introduced, my name is Nicholas Andre, and I'll be discussing the evolving definitions of family, the corresponding changes in legislation, and the legal implications for state law. So legislation is often a snapshot in time, and it cannot anticipate great societal or technological changes. For example, although there was decades of jurisprudence established for same-sex family rights in Ontario, the Children's Law Reform Act still did not allow for a declaration of parentage that would result in having two mothers or two fathers. In Ontario, on January 1st, 2017, the All Families Are Equal Act came into force. Its goal was to treat all children equally and end the uncertainty parents face when their children are conceived using assisted reproductive technologies. The act amended the Children's Law Reform Act, as well as a myriad of other statutes. So the amended Children's Law Reform Act now recognizes many ways to determine whether a person is or is not a parent. Notably, the birth parent, who is defined as the person who gives birth to a child, is a parent unless they are a surrogate, in which case special provisions apply. A person who provides reproductive material or an embryo for use in conception of a child through assisted reproduction is not a parent unless otherwise a parent under the Act. The standard rebuttable presumptions of parentage remain in instances where a child is conceived through sexual intercourse. There is a presumption of parentage if you are the birth parent's spouse at the time of the child's birth, as well as if you are living in a conjugal relationship with the child's birth parent before the child's birth and the child is born within 300 days after you cease to live in a conjugal relationship. Notably, a presumption of parentage remains for a person whose sperm resulted in the conception of a child conceived through sexual intercourse, unless that person and the birth parent agreed in writing to the contrary before the child was conceived. And so for any entrepreneurial Ontario state lawyers out there, I think that there is a market niche here for drafting non-intention of parentage agreements. And I'd consider either moonlighting outside of nightclubs or maybe even developing an app with DocuSign integrated for signature authentication. The Children's Law Reform Act also outlines that the spouse of a birth parent at the time of conception of a child conceived through assisted reproduction or insemination by a sperm donor is a parent unless before conception the spouse did not consent, the birth parent is a surrogate, or the child is conceived after the death of the person, subject to an application for a declaration of parentage. So the use of a preconception agreement in all these instances is vital. In combination with the legislation, it eliminates the need for the non-biological parent to go to court to have his or her parental status recognized in law. And it also settles in advance the legal relationship of donors of genetic material with respect to children born through assisted reproduction. The All Families Are Equal Act also permits multiple parents. So up to 4 people can be recognized without a court order if all parties enter into a written preconception agreement to be the parents of a child together. The new legislation is forward-looking and it helps families in the context of conjugal same-sex couples, non-conjugal parents, and multiple parent families. Although this is a significant development, the intention here is that you enter into a preconception agreement, whereas if a child is already born, these protections may not be available. And so this can be contrasted with the province of British Columbia's Family Law Act that has sort of a residual saving provision that allows the court to step in and make a declaration of parentage if there is any dispute or uncertainty as to whether a person is or is not a parent. Currently, recommendations are being put forth to the British Columbia legislature regarding updating their terms for parentage, including multiple parents that can go up to 4 people, for example, removing the genetic link necessary for succession law purposes on an intestacy, and for donor information transparency between the donor and the resulting child. So now that we've talked about the permutations of family in relation to parentage, we can look at how a spouse is defined. And so in Ontario, qualifying as a spouse is legislation dependent. It changes based on the legislation and also the intent of the legislation, whether that be support or division of family under the Family Law Act, tax under the Income Tax Act, or inheritance under the Succession Law Reform Act. For example, the Children's Law Reform Act, now amended, defines a spouse as the person to whom a person is married or with whom the person is living in a conjugal relationship outside marriage, and based on either qualification, you are considered a spouse. In many other jurisdictions, you have this idea of a civil partner, which is a different category altogether and does not have equal rights to being recognized as a spouse. So in terms of spouses and the rights that they sort of are entitled to under different legislation, the Family Law Act, in addition to legally married persons, includes those who are not married to each other but have continuously had a relationship of not less than 3 years. So this is typically referred to as common law spouses. Also, if you're in a relationship of some permanence and you have a child under the Family Law Act, you are considered spouses. This contrasts greatly with the Succession Law Reform Act that sort of settles how inheritance works in Ontario. So in Ontario, we have a very strong sense of testamentary freedom, and you could leave in a will your assets to whoever you want, which may include a common law spouse. However, if you were to die without a will, intestate, then that common law spouse would have no rights under the legislation compared to a legally married spouse. Further, if a legally married spouse was cut out of their deceased spouse's will or not provided for sufficiently, there are legislative grounds that allow for equalization protections. For a common law spouse, under an intestacy, for an example, the only recourse they have would be bringing a dependent support claim against the estate, or through the common law, bringing a constructive trust claim in court. So in summary, in Ontario, a married spouse has the right to property division on marital breakdown or death. They have a right to support, and they have rights on an intestacy. An unmarried spouse, if cohabitating for more than 3 years in a relationship of some permanence, or earlier if a child is born of the relationship, receives support rights, but no division of property rights and no intestacy rights. It's important to note that since 2005, the same laws which may apply to opposite sex spouses also apply to same-sex spouses. So there's no sort of special legislation, it's just that they are considered one and the same for the purpose of the legislation. Interestingly, when we look at the Income Tax Act, which is a federal piece of legislation applicable to all Canadian provinces, there's also a distinction as to spouses. So in addition to someone who's legally married, common law is considered to be at 1 year as opposed to 3 years. And then across all legislation, although the All Families Are Equal Act allows up to 4 parents, no legislation permits more than 2 spouses. So that's also the sort of the restriction that exists. So in Ontario before 1978, the common law applied a presumption that the words such as child or issue in a will, for example, did not include persons born out of wedlock unless rebutted by surrounding circumstances, such as acknowledging that person's existence or having a relationship of dependency. The law evolved with the adoption of the Succession Law Reform Act, which now provides that in any will, unless a contrary intention is shown, persons born out of wedlock are treated equally. And so there's the question of what happens then if there is a will executed or a trust that was settled before the Succession Law Reform Act came into force in 1978. And so the legislation does specifically note that it only affects those documents which are executed or settled after March 1978. And there was a recent 2017 case in Ontario which challenged this idea of the non-retroactive applicability. However, the court held that strictly to the legislation, providing that if the will in this case, which was executed in 1977, a child who in this case was a grandchild was born out of wedlock was not subject to any inheritance and therefore did not have those entitlements. And there was no rebuttable evidence in that case either, as no grandchild had been born at the time that the will was executed. So the legitimacy of a child born in or out of wedlock now seems a bit trivial, given that there is posthumously conceived children that are a factor in modern estates. And legislation has appeared in many jurisdictions to address this phenomenon. In other jurisdictions, they either haven't caught up or they decided outright against that inclusion. For example, the United Kingdom's Human Fertilization and Embryology Act permits a declaration where a man's sperm is used after his death, a declaration that he is a parent, but this is for registration purposes only and does not allow for the inheritance rights on an intestacy, for example. In Ontario, issue includes children conceived after and born within 3 years of a person's death. There are some requirements such as the need for a written consent agreement pre-conception, However, it allows for this 3-year gap. There was a 2019 case in British Columbia, which has similar legislation, and it was illustrative in terms of how this plays out. The court denied the surviving wife from posthumously conceiving using her deceased husband's reproductive material because there was no written preconception agreement. This was upheld on appeal. This case was distinguished from an earlier one where the surviving wife conceived a child after her husband's death without written consent. But in that case, the reproductive material had existed before the death of the applicant's husband. Thus, the material was considered his property, and she inherited that material as part of her inheritance of his estate. Further, he had given verbal consent and told many others of the plans for this to happen. In the 2019 case I discussed previously, the reproductive material itself was taken post-death. And I'll spare you the details as to exactly how that's conducted. So as we're touching on the intersection of property and succession law, I'll end with a bit of a thought experiment. Many of you may be familiar with the recent case in Alabama in the United States. At issue was sort of the Wrongful Death Act, which was amended so that it applied to an unborn child. And that was involving, that amendment had occurred because of a case where a child that was in utero died after the mother suffered injuries. The more recent case, the facts presented were that a person reached into a nitrogen freezer, pulled out test tubes containing embryos, and dropped the tube, resulting in the embryos dying. The question for the court then was there a ground for wrongful death? The court found that yes, as the embryo was an unborn child, there was a cause, which would allow for damages. So in looking at this sort of principle, we have to think of what the succession law implications would be. Many of you may be familiar with the existing doctrine of en ventre de sa mère, which references and includes issue conceived in a mother's uterus at the date of a person's death. However, should this doctrine evolve to something like en ventre de sa test tube? Should it allow for these sort of embryos that exist to also be included? Consider that we have in Ontario the posthumously conceived child's the ability for it to happen within 3 years post-death. Obviously, this poses practical issues in terms of administering a estate involving frozen embryos. Should the estate be paused? Should distribution somehow be limited in order to account for this? And should the idea of issue in this case be limited to those who are in utero? And would that solve the whole problem of even having this debate? So I think further reform may be needed as further family units continue to evolve and technology continues to evolve. And I'm sure within 5 years, we'll have a new update for you as to exactly how that plays out. So I'll turn it back over to Margaret for the next slides.
Thank you, Nicholas. Thank you for your presentation on all the challenges with different definitions. And I think one of the problems that we deal with in dealing with the modern family is that often a lot of the documents we use become outdated. So for example, a trust might have been drawn many years before and its definitions may be considered to be outdated, or maybe it has been drafted currently, but perhaps the beneficiaries think that in fact it doesn't reflect contemporary values. So how can a trust, for example, be modernized? What if it's not inclusive? Well, in certain circumstances, perhaps the trust may allow the ability to add beneficiaries if there's a power to do so. But what if there's not? What can we do? Well, another approach is to vary the trust. And under a legal rule, which you may be familiar with, called the rule in Saunders versus Vaucher, if all of the beneficiaries are adults and they all agree, they can wind up a trust or they can vary its terms. But the trust is that the problem is that trusts usually do have other interests, future interests, beneficiaries who have not yet been born or ascertained, or perhaps who are not adult, they're minors. And as a result, they can't provide a consent to vary a trust. So this is where variation of trust legislation comes into play, because it allows a court to provide consent to an arrangement on behalf of the minor, the unascertained, and the unborn beneficiaries. But in order to consent, there's a legal test that the court must determine, and that is that, in fact, the variation is for the benefit of the interests it represents. But what about the settlor's intent? What if there are specific clauses in a trust which exclude certain persons from being a beneficiary? For example, that it may not allow beneficiaries born outside of legal marriage or in a same-sex relationship or using reproductive technology or posthumously. So can a court on a variation override the settlor's wishes? Well, interestingly, these were the very issues that the court was faced with in the Jersey court in a case called Representation of Y Trust and Z Trust. The settlor had on purpose excluded certain children of unmarried parents and of same-sex relationships from being beneficiaries. It was right in the express provisions of the trust. But there were actually some existing family members who would be excluded as a result, including children of unmarried parents and of same-sex relationships. The family got together to vary the trust because they thought it would create division, and they wanted to preserve family unity and harmony. So in a nutshell, the court granted the order, and it approved the variation because it determined it would be a benefit to the minor, unborn, and unacted beneficiaries to have a broader definition, including because they may wish to have their children and other lineal descendants included who might otherwise be excluded. Now, in looking at the issue of whether the settlor's wishes should be taken into account, the court determined no, not in these circumstances. It didn't see its role to be one of to stand in for the settlor, as it said, but instead its role was to determine whether there was a benefit for the interests it represented. They considered issues of public policy. So one of the submissions was that whether or not the court should take public policy into account, including that it would be actually harmful to Jersey's trust industry if a settlor's wishes were not upheld. And the court considered as well public policy in Jersey within the context of its current human rights legislation as another important public policy consideration, which it thought on balance outweighed any benefit to the trust industry. So in this case, we can see the ability of a court to actually vary a trust to make it more inclusive, not exclusionary, but of course, this avenue requires a consensus of the beneficiaries and of course the agreement and approval of the court. Now, with regard to a will, I think there's less scope for making a will as opposed to a trust under a will more inclusive, because the general principle, at least in most Canadian jurisdictions, is testamentary freedom. So we have a bit of a dichotomy here, I think, because, and it's difficult to reconcile with regard to the importance of a settlor's wish, of a testator's wishes with regard to testamentary freedom, as opposed to under a will, where we see a court actually overriding settlor intent. So interesting in terms of the two different avenues and the two different approaches. Well, now I'm going to turn to the topic of modern family multi-jurisdictional issues. What happens when we have a will cross a border or a trust and we have many different definitions, and how do we navigate that? We've just finished discussing how diverse the definitions may be of who is a parent, who is a child, who is issue, who is a spouse in different jurisdictions. And we spent quite a lot of time talking about Ontario, but we also realize that Ontario may not be that representative when we look at different places around the world. So when there is a class gift, which does not name a specific person, but instead a group of people, such as my children, my grandchildren, or my issue, the problem is, well, which definition do we use if a will or a trust prepared in one jurisdiction has application in another jurisdiction? And the definition is actually very different. I thought the best way to deal with this issue is actually to look at a few examples. So I'm going to take you through them and try to illustrate what the problems can be. So my first example, a will is prepared in Ontario by Heather using a software program. Heather had lived for the last few years in Ontario, but she was born and lived in the Bahamas before moving to Ontario. Now, there's no definition for the term children or issue in the will that she prepares, nor any express provision for which law governs construction of the will, nor any indication in the will of which law governs. Heather dies owning real estate in the Bahamas, as well as financial assets in Ontario, and under her will, all of her assets pass to her children. And she doesn't name them because, unfortunately, the software program didn't allow her to do that. Let's assume that under Bahamian law, children means only children by blood of an opposite sex couple born in legal marriage or whose parents later married after a child's birth, but not otherwise. So it doesn't include children born outside marriage. Heather had one child born in legal marriage and two children who are from a prior common law relationship. Now, under conflict of law rules, a testator can make an express choice of law in a will to choose which law will govern its construction, how we interpret the terms of the will. But if there is no express or implied choice of law, then the assumption will be that the testator's intent was that their domicile should govern. The domicile at the time of the execution of the will in determining what the intended law should be. And that applies with regard to both movable property and immovable property. Movable being personal property and movable and immovable property being real estate. So here's the analysis. If Heather's domicile is the Bahamas, which it may well be, she's only lived in Ontario a few years, the children born outside marriage will be excluded under her will. But if in fact she made an intention to permanently live in Ontario and it's her permanent home, then essentially her domicile will be Ontario and all of her children will be included. So there's an example. Well, what could Heather have done? Well, she could have named her children, or she could have made an express choice of law that Ontario governed construction of the terms of her will. And perhaps this illustrates some of the issues and the problems can develop in using a software program. Let me give you another example. Ben, a Canadian, was born and bred in Toronto. He executes a separate situs will in Italy, an Italian notarial form with references to Italian law, and it provides for all of his Italian property, both real and personal, to pass to his, quote, grandchildren, but he doesn't expressly name any of them. And of his 6 grandchildren, 1 grandchild was born outside of marriage, and 2 grandchildren were born inside legal marriage between his son and his son's husband, as they are a married same-sex couple. Now, under Italian law, the grandchildren born outside marriage and the grandchildren born inside legal marriage in a same-sex relationship will not be included, given that Italian law, which will govern construction of the will, as well as Italian public policy considerations, doesn't include or recognize them as grandchildren. Now, Ben could have included the names of his grandchildren, or he could have provided that Ontario law governed his will by making a declaration under the European Succession Regulation, because he's a Canadian national, and he could choose the law of Ontario as being the jurisdiction which has the closest connection with him to govern his succession. So there are different ways that we could have approached this issue with the proper legal advice. My third example, we're going to deal with an intestacy here. So Maria dies intestate. She's got real property in Dystopia, but most of her assets are in Ontario. And she and her wife, Leela, they have 3 children born of their marriage. Maria is the birth mother of 2 of the children. Leela is the birth mother of 1 child. Now, under Ontario law, Maria's domicile, which is Ontario, will govern succession of her worldwide movable property and her real property in Ontario. So on her death, her intestacy, her wife Leela will be entitled to her preferential share of $350,000. The remainder of the Ontario estate will be divided equally among Leela and the 3 children, as Ontario, since of course 2005 has recognized same-sex marriage, and since 2017 that the children born in legal marriage, conceived without a spouse's genetic material, is their child. So the child Leela is the birth mother of is also, of course, Maria's child. But what about dystopia? Well, under its law, there must be a genetic link for a person to be a child, or they must be legally adopted to be entitled to share on an intestacy. So as a result, only the two children for whom Maria is the birth parent will be entitled to share on Maria's intestacy, and not the child for whom Leila is the birth parent. So what's the solution? Well, first of all, don't die intestate. Do a will, because the local law otherwise will control and not you. And that's one of the big problems with not having a will in place. So conclusions, we need to be very careful when there's any interface with another jurisdiction in our estate planning to understand how local law may apply, how best to proactively address issues involving definitions, class gifts, how children and grandchildren are defined, including those born inside and outside of legal marriage, recognition of same-sex marriage and children of a same-sex marriage, or an opposite-sex marriage where one parent has no genetic link. Our next topic is gender identity and fluidity and their impact on estate planning, and my colleague Blair Botsford will speak on those issues. Blair.
Thank you, Margaret. So first issue here is, how will documents prepared today be received in the future in light of gender identity or gender fluidity issues? Legal documents and how they'll be received is always a concern. It's something that gives lawyers more than a little bit of heartburn. But this issue may be harder to predict. It's quite a sensitive issue. Clients simply might not be aware. There might not be anything that for them is on their radar as a cue that maybe they should be talking to an intended beneficiary to ask how that they would like to be respectfully identified so that it's clear. Or they might think it's a personal issue, this is a family issue, we don't talk about this outside the home. So it just may not be something they're aware of for one reason or another. They may not be comfortable to speak to an intended beneficiary to ask, how is it that I should reference you for legal purposes? What are you most comfortable with? Or they might not be comfortable to talk to the lawyer. They think maybe they should be aware of this issue, but this isn't something they want to bring up in a professional setting, so it goes unaddressed. Even if the client and the lawyer do attempt to properly reference a person in a respectful fashion, they still may not get it right. Language and understanding may evolve. So what's an acceptable drafting standard today, 10 or 15, 20 years down the road, it may not be the norm anymore. And then, best efforts of the client and the lawyer to be respectful and properly identify someone could still land badly, because if people are making assumptions about what's respectful by their standards, if they're not talking to the person affected by that, it still may not go over well down the road. So, if we could back up just a second. So where this uncertainty and confusion can lead to problems is that if people aren't identified accurately, and if we're relying on traditional binary terms, and talking about, all my jewelry to granddaughters or my family Bible to eldest son. So that could lead to uncertainty and misunderstanding about what was intended by the testator. Was it inadvertence that made them just reference granddaughters or son because they're sort of on autopilot and making assumption about what people would want? They never meant to bring gender into the issue. Maybe they did intend it to be a factor, but at what point was it a factor? Was it to capture people who would be identified by gender in one way or the other at the time of drafting? Or is that supposed to still hold true at the time when they've passed away and the will's being interpreted and the estate is being administered? So, it creates this confusion and uncertainty. How many people, who is in this class or meets this definition? So where all this can lead is, besides conflict amongst beneficiaries, it could lead to an application to court for an interpretation to be clear about what the testator intended. And if beneficiaries would benefit from someone no longer fitting with within a gender-based classification, more stuff for me, more money for me, they may try and challenge the will in the estate to oust a person's entitlement. So, the balance of the group gets more out of it. As we've heard, sometimes identifying people by name can help clarify a situation, depending on what legal rules you're dealing with in certain jurisdictions. But people can change their name for reasons other than gender identity. They just may not like their name. And so sometimes what could be helpful still may not address the problem because people may change it for gender-related purposes, and we're still not clear. Next slide. No. Sorry, that doesn't. Nope. Oh, yeah. So, no. Go ahead. Yeah. So, practical steps in helping to create less of a focus on gender, more neutrality in documents. So, instead of using the traditional terms he, she, son, daughter, etc., what we can do, and what's happening in the legal industry, is a move towards they and their. On one hand, it seems more impersonal, but it avoids gender-biased terminology. And there are other neutral terms we also use, grandchildren rather than granddaughter or grandson. So we're talking about a degree of lineage, descendants down from the testator or another reference person. Niblet is the gender neutral term for nieces and nephews, sibling rather than talking about brother and sister. Again, it can be impersonal. Not all clients like this, but I've explained it to them that actually it avoids a range of problems, including as a class grows, accidentally leaving people out. If you say grandchildren being A, B, C, and D named persons, well, what if E, F, and G are born later? Were you intending to exclude them? Were those just examples of people fitting that class? So no matter what you do to try and resolve the problem, there's not a perfect solution. And as you broaden a class by going from granddaughter for one grouping, grandson for another grouping, just talk about grandchildren, you're not talking about divisions of money. You might need a way to let people select what they want and not assume that people that identify as female or male would want certain items. So if you put in a selection mechanism, you can help avoid some assumptions and bias. Adding a definition or admin provision to the document that says a change of name, a change of gender identity does not disqualify a person could help with that interpretation issue down the road. And I think we're up to poll question number 2.
Great. So poll question number 2, what do you think is most important in dealing with the multitude of issues which you've heard today, which impact the modern family? Do you think it's more education on the issues, tolerance and respect, or professionals who embrace change, keep current, or modernizing the law, or perhaps none of the above? Give you a moment just to put in your response. Okay, and here we have it. More education, looks like a third of you. Tolerance, respect, 10%. Professionals who embrace change, well, we've got a hearty almost 40%. Modernizing the law, about 14%, and none of the above 3. So it looks like the professionals need to up their game a bit here when it comes to all of these issues and become more current and embrace change. Now this concludes the substantive portion of our program. Wanted to direct you, though, to a few resources that you might wish to look at when it comes to the topic of modern family, a few blogs which we have written, and you can find them all on our website. But as well, I would heartily commend you to look to the STEP portal, which has all kinds of resources on the topic of modern family. You'll see one that we've identified here called Meeting the Needs of Modern Families. And next, I'd like to talk a little bit about our blog. We put it out every 2 weeks. We've been doing it now, we're into our 11th year consistently. We like to be very topical, talk about issues and trends, a lot of thought leadership on matters of interest. It's quite short, about 500 to 600 words, so it doesn't take very long. And if you're interested in subscribing to our blog, not already done so, you can very easily do so right now by saying yes to the blog. And I'll give you just a little bit of a moment if you'd like to take the opportunity to consider whether or not you would like to be on our blog. And if you do sign up, I can tell you that you will, as a bonus, receive our 360-page book called Trust and Estate Essentials with our compliments. Okay. And of course, we'd love it if you would visit us on our website at www.o'sullivanlaw.com. A lot of resources there. We've got over 20 advisory letters. And as well, please add us to your LinkedIn. Now for our question session. I think we've got quite a number of questions have come through the chat box.
Yes.
And over to you, Dan. Dan, I think you're going to lead the question session.
I will do. And just before we move to the Q&A section, I'd like to say a big thank you to our panel for their time and their insights today. A truly fascinating session and a very important topic, I feel. So we have a little bit of time now. If you do have a question, please do send it in. Even if we aren't able to answer it, we will be sending it on to the panel who will be in touch. My first question is to Michael. You mentioned dying on an intestacy. My apologies if I pronounced that incorrectly. What does that mean and what implications does it have for the estate of a deceased spouse in a blended family?
Sure. I believe the term you stated was intestacy. So the idea is passing away without having a will in place. And of course, Margaret mentioned the idea of the potential application of conflict of laws issues, which we'll set aside. If we focus on Ontario specifically, the issues that can arise, as we discussed, are A, the Succession Law Reform Act is going to govern the distribution of the assets. And specifically with reference to the presentation, there's the question of the preferential share. That first $350,000 is going to the surviving spouse. Then the children's share in the remainder of the residue. It depends on the number. If there's just one child, then it's a 50-50 split between the surviving spouse and the child. If there's two or more, it's a 1/3 share to the spouse, 2/3 to the children. And the issues there are, I mean, A, did you intend for your spouse to share in the capital, especially in a blended context? Did you intend for your children to share in the capital, especially while your spouse was still alive? And moreover, who are your children? Does it include your spouse's children? And on that particular issue, it's ripe for litigation. And I think I would leave it there. Just in a nutshell, the Succession Law Reform Act governs, and there are issues arising as a result that may not occur with the intentions of the deceased.
Thank you very much for that. Thank you very much for that. This question to Blair. What can clients do to avoid confusion and conflict between beneficiaries regarding their respective intentions about gender identity or indeed any other issues?
Yeah, thank you. That's a good question. And yeah, I like the bit about any other issues. These days, transparency is helpful. So rather than traditional sort of secretive planning, mom, dad, grandma, grandpa, anybody does their planning and it just lands on people. So to have a discussion up front with beneficiaries, at least at a high level. You're not necessarily seeking approval from family members, intended beneficiaries, saying, do you agree with my plan? If not, I'll change it for you. But at least people feel heard. They've had a chance to provide feedback. So if nothing changes, ultimately, they at least feel heard. So either it could be one-on-one discussions, it could be a family meeting. If clients don't feel comfortable to have that group session and go through an overview of the plan, there are facilitators who can conduct family meetings. So there are ways to help do it, but transparency really could help avoid unintended results, conflict, and really expensive litigators. Apologies to my litigation friends.
Brilliant. Thank you very much, Blair. Margaret, I was surprised to hear that many children born outside legal marriages being children for the purposes of inheritance, unless the person who makes the will makes sure to include them. The common law relationship, for an example, we have two children. It scares me that they would have lesser rights under the law if I move to a place with such laws. Do you have any comments or recommendations on that?
Well, it's always important, I say, look before you leap and really understand what the culture that you're moving to is all about, and what the legal terms are, and how they might differ from where you're coming from. I think, unfortunately, we all kind of live a bit in a bubble. We think that everywhere in the world is the same as where we live here, and quite frankly, it's not the case. The world is very diverse and very different treatment of these sorts of issues. So it's really incumbent, I think, on the person who's making the change to really get to know what, in fact, the law is in the new place that they're moving to, and to be very proactive on these issues. And as I hope everyone can appreciate today, it's a complex area, and there's a lot of diversity. And what we have here in Ontario and some of the Canadian jurisdictions, what applies south of the border, what may apply in Europe, what may apply in Asia, it's a big world out there. So be proactive. Get the advice and basically put in place a good solid plan to protect your family at the end of the day. That's what we want to do, protect the modern family.
Absolutely. Thank you very much, Margaret. And if you do have a situation like that, we do encourage you to get in touch with O'Sullivan. Nicholas, we have time for one more question. So if I could ask you, is there a need for parentage under the legislation to extend to born children? Do the current adoption processes not cover that?
Yeah, so as I discussed in the presentation, the parentage is limited to 4 people, and you have to enter into a pre-conception agreement. So if there is a born child and you all wanted to become the parents of it, there is a bit of a gap. And so the adoption process currently would require a parent to give up their rights to a child in order for someone who is not blood related or not related by marriage to become a parent. And there was a recent case before actually the All Families Are Equal Act came into force. There was a case where 2 best friends, non-conjugal relationship, both wanted to become the parents of one friend's child who had very extensive special needs. And ultimately they were allowed to do that by the court at the time. But now that we have the All Families Are Equal Act sort of implementing this preconception intention, we're not sure if that really would be allowed. And so that is where the gap remains.
Excellent. Thank you very much, Nicholas. And I think that we will need to wrap it up there. But once again, I would like to say thank you to our panel, to Margaret, Michael, Blair, and Nicholas for your time today. It's been fascinating to spend an hour in your company today. I hope that we can do so again soon. And thank you very much to our audience for being with us. We really do appreciate it.
Thank you, everyone.
Thank you very much. Wish you a lovely rest of your day.